Thank you very much, Angelo. And please interrupt me if I have any internet disruption, because I started to have a small ones while you were introducing the topic. So I hope technicalities will not be an issue this evening. Good afternoon or evening, everyone. I saw some names that I know, so I'm very happy to see you here, not see you, but at least that we are in the same webinar. So my name is Benedicte Colin. I'm French. I work as policy manager in FAFCE for the past more than 3 years now. And we do follow, as a Federation of Catholic Family Associations, every EU files related to the family. And we have a very heated debate nowadays in Brussels regarding one specific file that you just mentioned, which is the cross-border recognition of parenthood, also known as more commonly as the EU Parenthood Certificate. So what I will do today is briefly introduce to you the topic, what are the main concerns that we have, what is the state of play, and where we are heading overall. So as a first word, I'm not a legal expert, so I'm only speaking more from the legislative perspective. So I hope I will still be able to answer if you have any questions. So maybe on that note, I will directly jump into the presentation. So I will share my screen with the short presentation. So I hope you can see it.
Yeah. Perfect.
Properly. Perfect. So to introduce the initiative, so everything started already before the pandemic, actually, in the fall of 2021, during the speech on the State of the Union, which is a speech made by the President of the European Commission, a bit like in the US with the American president during the State of the Union. So Ursula von der Leyen, President of the European Commission, mentioned in her speech to start the year and introduce the work program of the European Union. She stated that if you are a parent in one country, you are a parent in every country. So this is mainly the idea that would summarize overall the commitment of the European Commission to have by the end of its mandate a piece of legislation that will support this statement that if you are recognized a parent somewhere in Europe, you would be automatically becoming a parent in every country of the EU. So I will stress two words in what I just stated: the word if you are recognized, parent, and second, automatic recognition. So those are two key elements that I will touch upon during this presentation, but are, of course, have huge impacts in terms of national legislation and the protection of family law and marriage in general in Europe. So to give a bit more of insight, so what does it mean to be a parent in one country and then to be a parent in every EU country? It means that in situation where you have an element of cross-border, which means that, for example, you have a movement of a family, for example, from Italy to another country, to France. So in a situation that is cross-border with two countries that are into question, you would have an automatic recognition by the state that is welcoming the person that is moving in the country, for example, of the parenthood that is established in the country of origin of the Europeans that are traveling to this country. So the idea as freedom of movement, that the recognition as for identity cards, for example, it will be the same with filiation and parenthood. So as I already stressed, you can already feel like that if you have a parenthood that is established, it's not exactly or objectively always determined by biological links. So we are not always speaking about biological mother or father, but any situation where you have parenthood that is recognized. I will speak a bit more about parenthood in a few minutes and what this word means in general, legally speaking. But you can see that, for example, in situation of same-sex couples or couple that are single persons, or in general, yes, the question of surrogacy. So in this situation, surrogacy is included in such piece of legislation, especially. So that's one of our main concern, beside a conflict with marriage and family law. So first, to start with a bit of vocabulary, sorry for that. The word parenthood. In EU law, until now, EU legislators were mostly referring to filiation when it comes to family legal recognition of family connection and links. Filiation being understood until very recently as the biological connection between a father, a mother, and a child. However, with the new wording parenthood, it allows the EU legislators to go beyond even the question of biological connection, and we only have as parenthood, which is not a legal term, but is used in general to say when someone is acting in fact as the parent or the guardian of a child. So that is ensuring the role of a parent, which is very different from being a parent and ensuring the role of a parent in reality, in concrete terms. So as the Commission, when we ask several times about the European Commission, when it comes to the impact on such a new legal category of parenthood on national law on marriage and family, they mention the fact that it will not have any impact because we are not here speaking about marriage or what is a family, but, and that's the important element, the legal effects are the same. Even if you don't recognize same-sex marriage, the fact of recognizing the effects, or same-sex adoption, the fact of recognizing the effects with saying that this is the parent of a child, even if they don't have any biological connection, is basically creating legally an ad hoc recognition of such a situation, even though you don't have it in national legislation. I don't know if I'm clear. It might become clear afterwards. It's a bit of a technical file, but it's very important to understand the subtleties, because as it is portrayed nowadays in Brussels, it's very much only portrayed as something that is to adapt to a reality that is already existing. But to do so, we are changing laws and way legal categories are formed in order to adapt legality to a reality that is actually biased. And so all these general debates, there is one specific element, which is, you mentioned it, Angelo, the European Certificate on Parenthood. So that's one element of a broader EU proposal for EU legislation. So what is this European Certificate on Parenthood? Basically, it will be like an ID or a European, health card in general that you can have. So this will be a proof that of parenthood that will be granted by the national state, but that will be an EU document that is recognized everywhere in Europe. It's not mandatory. So here we could say hallelujah. But the thing is, there is the catch, because the state will be obliged to, in any case, grant the same effects. So that you can use another tool, another document, but the effects have to be the same as the European Certificate on Parenthood. And by effects, we mean the automatic recognition of this parenthood connection between these parents and this child. So that's one element. So the European Certificate on Parenthood is not the only object of this new EU legislation, but it's the most striking element that really summarizes all the different problematics that are with it. So now just to touch a bit upon the different clash of competencies that this legislation would entail. So of course, there is always the principle of subsidiarity with a clashing national competence on family law. And as I was mentioning, at the EU level, the EU competence on the freedom of movement allows the European Union to legislate on questions regarding family law, but with cross-border implications, which is the situation we are in now in this regulation. The issue coming with the fact that even though the European Union has a competence, there is a principle of proportionality. So how much does it violate the national competence on family law? And here, what we don't hear very often is that the EU and the European Commission has many instruments, legal instruments that it can use. So it can go from a directive, which is basically like a law and will have a direct effect in national legislation, a regulation that is more or less the same, but a bit less with transposition times, and it's a bit different, but it's as well as like it was a law at the European level. And there is what we call enhanced cooperation, which is that countries agree to cooperate a bit more, but while keeping always their national legislations and just working together. And in this question, for example, of cross-border recognition, that's what we've been calling for more judicial cooperation mechanisms, for example, but stressing the fact that according to the principle of proportionality, that is a safeguard of the principle of subsidiarity, the EU is not legitimate to ask for such a strict and strong instrument, such as a regulation, what is planned for now, and could only choose and opt for the option that is less constraining of enhanced cooperation, which would be completely enough to deal with the situation, because we're not speaking about billions and billions of children that face this situation of cross-border family situation. So that's a bit for the two key elements that we see are clashing now, currently in the debates in Brussels here. And now I want to touch a bit upon about the specific issue of and question of surrogacy. So what is a national situation? Because we hear many discourses and many speeches on this situation where surrogacy would be almost legal everywhere in Europe, which is completely false. And there is a lot of wrong information in that regard. So most EU countries forbid this practice. I listed them here on the slide. And for the rest of EU countries, the fact that they do not forbid it doesn't mean that they allow it. For some EU member states, for example, they just don't mention it in their EU legislation. So we cannot say, of course, it's in practice is then legal if it's not made illegal, but it does not mean that it's encouraged and that the state actually tackled the issue until now. At the EU level, something that is quite interesting and is not often mentioned is that the EU has a competence when it comes to the question of human trafficking, because it has a question of freedom of movement, because human trafficking most often is happening between several countries. And there is currently a review on all the EU rules when it comes to human trafficking, and we've been advocating to include as well surrogacy as a situation of not sexual exploitation, but reproductive exploitation, which is something that the EU could be completely legitimate to legislate on. But we see, of course, there is a double standard when it comes to the fight against human trafficking, because the situation of surrogacy, that is definitely a situation of reproductive exploitation of poorer women for the sake of richer couples, especially from Western Europe. And it's not a situation that is even touched upon a bit when it comes to the different discussions at the EU level on human trafficking. And just to mention another element, stating that there is no consensus on the question of surrogacy at the EU level, and everyone that will say that would actually be very wrong, because 3 months, if not 4 months, right after the speech of the President of the European Commission, von der Leyen, the European Parliament actually adopted a resolution where they're strict on human rights in Europe, and where they strictly mentioned that sexual exploitation for surrogacy and reproductive purposes is unacceptable and a violation of human dignity and human rights. So when we see that the European Parliament mentioned in one resolution such statement, we cannot really say that it's a consensus when it comes to surrogacy at the European level. Which, just to state it very briefly, it was the result of this resolution at the European Parliament was the result of a very long work of our federation to raise awareness on surrogacy. So that was one big success at the European Parliament. Now to continue, one of the main justification of this legislation, according to the European Commission, is not for the sake of couples, especially same-sex couples that will need surrogacy, but it was reiterated repetitively from the European Commission and the people we meet that it was to serve the best interest of the child. And those children that are living in those situations where some of them are stateless, they don't have any paper, or the question of inheritance, they will not be able to inherit their parents because officially they are not their parents in this country. For example, imagine a child that will arrive in Spain from a same-sex couple from Ukraine that got the child for surrogacy. The child could potentially not be recognized as the child of those people if there are no biological connection between them. So we see a lot of emotional discourses about children that will have to face severe discriminations, especially when it comes even to family benefits, access to family policy, childcare services, etc., because of a lack of automatic recognition of a new type of parenthood. So I really want to just stop a moment on that question of best interest of the child, because it's really important to know what legally it means, because we can speak about it from a very emotional perspective, but it's important to go back to a legal perspective. So according to the UN Convention on the Rights of the Child, let's take the biggest and most legitimate, if we can say, document in that regard, the best interest of the child shall always be a consideration. That was the Article 3. And what are those best interests? And we just move a few articles below, and we see at Article 7 that the child shall be registered, of course, have the right from birth to a name, the right to acquire a nationality, etc. And as far as possible, the right to know and be cared for by his or her parents, which is then the best interest of the child, beside having a name and a nationality, is to be raised by his parents. And it was signed and ratified, in 1989, where it was clearly understood when people were saying parents, they meant biological parents, if we have a bit of an historical approach. So we can't really say that it cannot be parent of intention. It was definitely understood as biological parents. I wanted to stress another thing on the question of the best interest of the child. So in a situation of surrogacy, of course, you have a violation of the rights of the mother, but as well of the child that becomes the object of a business. So it becomes a merchandise and an object, basically. So can we speak in a situation of surrogacy as the best interest of the child? In addition, the European Commission then used the argument that even though it was not optimal at first, the child is already here. So what do we do with that situation that we are confronted to right now in front of our eyes? And that's where the loop is happening, because this situation that we are facing with regard to the question of surrogacy is a situation that could have been avoided. And couples that choose to use surrogacy to have a child, being in a country where they are completely aware that it's illegal, and if they have a child, this child will face legal uncertainty and will not be recognized as their child, are purposely, on purpose, and being well aware, they are creating a situation that they are already aware that will be very detrimental to their so-called child. So then the idea of what we could even argue in that sense, that they did not ensure the best interest of their child, and second, that they purposely did something that will harm their child later. So it's actually the opposite. They served the worst interest of the child by doing so. So then we have the question, if the parents want to have a child, absolutely parents of intention, I'm here speaking, want to have a child, what about the child happiness and his best interest? And to continue on that on that note, I want to make a brief comparison with the question of international adoption. Because definitely with this regulation that is proposed by the European Commission, we will see a situation that will create a double system of ways in a way to become a parent without like having going through the biological procreation process in a way. So it will create a double standard between the surrogacy processes and the adoption processes, because adoption is a very rigorous and intensive process that prioritizes the child well-being at the necessary cost of long wait times for parents. We are all aware of that. So couples, they have to wait a very long time and pass a very difficult process to be approved for adoption and confirmed in the capacity to become a parent. So by choosing surrogacy over adoption, those couples demonstrate that they value their interests over those of their children. So in the situation of adoption is the opposite. Parents prioritize the well-being of their children, even maybe at the risk of not being able to become a parent before their interest, which is, again, the opposite in the question of surrogacy. So if we continue this comparison, what do we do? If we accept situation resulting from surrogacy, then should we stop to require anything from the parents that want to become parents through adoption? Should we remove any safeguards for the well-being of children, because to ensure that there are no discrimination with the practice of surrogacy that has absolutely no safeguards for the well-being of the child that are born out of surrogacy? I'm just checking if I didn't forget any point here. And I wanted to stress the last point. The surrogacy arrangements there are mistakes, sorry for my English, lie on the biological reality of the child. It's very interesting because in some surrogacy arrangements, not all, but the donor remains anonymous. And it's actually a human right of a child to know his parents. And in the situation of surrogacy, more than that, which is even more problematic, in some EU countries, it can be written in the civil register that the parents of intention, not the biological parent, are the biological parents. So you can basically completely lie on the filiation, and a child could never, for example, never be aware that his parents are not his biological parents. So it creates a system of lie that could have tremendous implications overall. And now to conclude very briefly on the calendar of the initiative. So as I was mentioning, the Commission was speaking about it already in 2021. The proposal was only published in December 2022, so 1 year after, a year after, so it took some time before. And now, what is the step? So the legal basis that was chosen by the European Commission is quite peculiar, because they did not choose to have the usual legislative process, which is to have both the European Parliament and the Council of the EU deciding, so the head of states, the governments, and the members of the European Parliament. The procedure that was chosen was the one of adoption with unanimity at the Council of the EU, and the European Parliament will only be consulted, so will have no power whatsoever in the situation. And so basically what will happen now, so we have a report that will be adopted by the Parliament, but will have no impact whatsoever on the situation, beside proposing to the attention of head of states some amendments, but they're completely free to agree or disagree. And the question now is, will this proposal be adopted by unanimity at the Council of the EU? And we are well aware that there are some governments at the EU level that are against this initiative. So in theory, it should be blocked, and the proposal will not go on afterwards. However, there are two options that we see are feasible. One is to adopt adopt the proposal with surrogacy is mostly impossible, because even countries like France mentioned that they were not really sure about it. But there is a risk of having an adoption of the regulation with the question of surrogacy removed, but it does not mean that it will be a good regulation at the end, because even if you remove the question of surrogacy, you will still have situation, for example, of people that had a child for different, like for example, in vitro fertilization. No, sorry, not that, but for example, had with it's registered with their couple that they are a child, and then, for example, they remove their from the couple, and then they start a couple with the person of the same sex. You could have then a recognition going through that, not necessarily going through surrogacy arrangements. And in any case, even if the regulation is adopted without surrogacy, then you create a situation that is very usual, is that a situation of discrimination towards same-sex couples that had children through surrogacy. So even if the EU is adopting this regulation without surrogacy, they mentioned like the inclusion of surrogacy practice in it, you can be sure that at the Court of Human Rights in Strasbourg, the European Court of Human Rights, they will disagree on that point, and that the Court of Justice of the EU will have to then modify the decision of the European Union. However, in this situation, as far as we know from our information, it will mostly be paused and not adopted by the end of the mandate of the EU, so until next spring. This is not sure information, but as far as we know, it might be delayed. So there is as well a risk of this proposal being delayed for several years and waiting for some, for example, for some changes of governments in order to then be adopted through unanimity. So there is a risk, even if the regulation is blocked, it cannot be blocked forever, for example, and there is always a risk of this regulation to pass in general. So that's it on my side. Thank you very much. I hope I was clear. It's a quite technical topic, so I hope maybe if I wasn't, I will be able to answer some of your question. Thank you.